Good morning and welcome into another episode of the After Parties Meet the Jury segment. I am Tam, your host, not your lawyer, but your nosy best friend. And this is where you come to get all of your courtroom tea served piping hot. Welcome in this Saturday morning, this rainy Saturday morning. We're going to be continuing to go over the Karen Reed trial one sidebars. We got a lot to uncover today. We're going to go overtime today because the video is an hour plus. So with my pauses and such, we're going to go a little bit over. So let's jump right in and get right to it today. We don't want to waste any time. So let's go.
Anything to do before the Honorable Beverly Canoni, Justice of the Superior Court, holding in Dedham within and for the County of Norfolk. Join in, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is in session. Please be seated.
Thank you. Please be seated. Close the session.
22117 Commonwealth versus Karen Reed. Counsel, please identify yourselves for the record.
Adam Lally for the Commonwealth. Good morning, Your Honor.
Good morning, Mr. Lally.
Good morning, Your Honor. Laura McLaughlin for the Commonwealth.
Good morning, Ms. McLaughlin.
Good morning, Your Honor. Alan Jackson for Ms. Reed.
Good morning, Mr. Jackson.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms.
Good morning, Ms. Little.
And good morning, Your Honor. David Yannetti for Karen Reed.
Good morning, Ms. Giannetti. Good morning, Ms. Reed. All right, did counsel want to see me at sidebar?
I had asked, Your Honor.
Okay.
Thank you.
Sidebar one, let's get the counting.
I thought it made sense, Your Honor, because we are having the witnesses that are coming up who will involve federal documents, potentially admissible, potentially usable. And we wanted to get some clarity as to how we refer specifically to, testimony before a different grand jury other than the grand jury in this case.
Well, just grand jury and a date, right? Because the dates are off by a year maybe, or how long?
About a year. Right. Well, our concern is we don't want it to be left, the jury to be left, with the impression that the Commonwealth in this case convened another grand jury and that they were the ones asking the questions of the witnesses. Our position is the context matters. And our suggestion was going to be that the witness be alerted to the fact that this was a different grand jury conducted by a different office or agency, and that neither Mr. Lally nor I, the prosecution and the defense in this case, was not involved or present.
Okay, so I kept out the whole federal.
Okay, so real quick, the reason why they're having this sidebar or this discussion, exactly, Jen. The reason why they're having this discussion is because they did not want to allude to a federal investigation in this trial, because there was a federal investigation, like basically the Commonwealth and the handling of this trial was investigated. So the investigators are being investigated, and they didn't want to allude to that. They didn't want the jury thinking about what other investigations was happening and why. So they're trying to figure out how to discuss this particular grand jury because it wasn't conducted by the Commonwealth. Okay, so that's why they're having this sidebar.
I haven't mentioned the word federal.
No. So I think it's just you testified before a grand jury on this particular date, and Mr. Lally wasn't there and I wasn't there.
Okay, we can deal with that.
Thank you.
Secondly, now I've lost my chain of thought.
The security issue is what I thought we were coming over for.
Oh, yeah, there was that too. That is the second issue. Yeah.
That should have been the first issue. All right, so as far as I'm concerned, it is certainly a very important issue. Mr. Fahey, please, Assistant Director or Regional Director, could you please come and just report on the record, and all this is sealed on the record, what the trial court folks have done?
All right. After looking into an incident reported to us, the security department concludes that one court user's behavior did not align with the proper dignity and decorum expected in a Massachusetts courtroom. As a result, we have informed the party that he will not be allowed to enter Norfolk Superior Court for the duration of this trial.
That's acceptable to us.
And you've already told them about assigning Officer Dunn?
We discussed that with our client. I think our position is my client being allowed to use the court officer's bathroom, which we greatly appreciate, will solve the problem here. She doesn't need somebody walking with her through the courthouse because she has counsel. She is almost always with somebody.
I was surprised, frankly, that you weren't with her on this occasion when she walked down the steps.
Almost every time when she goes to the bathroom, I go with her. For whatever reason, I didn't this time.
There are so many bystanders. And just so the record is clear, what we have proposed and what we are willing to do is assign a female officer here to your client. Eugenia Dunn is a phenomenal officer. She has worked closely with me on trials and has been assigned to protect me during trials in this building. She's fantastic, and she will simply walk with your client anytime she leaves the courtroom.
Sheesh.
But if you're telling me you don't want that, we won't do that.
We don't. And I would put on record that the security in this case has been phenomenal. We appreciate all the consideration from this court and the security, but I think we'll be satisfied as long as she can use that bathroom.
Okay.
Just one other issue, Your Honor, which you don't have to give us an answer now, obviously, but I wanted to flag it for the court. We are breaking for Memorial Day weekend on May 24th. That is the Friday. We have obviously the Monday off because that is Memorial Day. And then we have another off day, I believe, on May 29th, which is that Wednesday, which means that the only court day that we have been, the 24th and the 30th, would be a half day on the...
So, do you want it to go all day on the 28th?
Well, I was going to ask if we could have that day off instead of going a half day. The reason, Your Honor, is the trial is difficult on the lawyers, but that's not the issue. It's more difficult, I would assert, on the lawyers' families.
I don't have a problem with changing the schedule. So I can tell you on that week, on the 30th, that Thursday, a juror has a conflict. We'll probably stop at 12 on that day. And we are not in session on the 29th and 31st. So if you wanted to have the 30th off, it would be 2 long weekends in a row for counsel. It would be...
That would be incredibly nice.
So you'd have the long weekend. We would break on the 24th, and you'd be off the Memorial Day, that Monday, the 27th. We could do a full day on the 28th and then have Wednesday, Thursday, Friday off.
That's great.
So you'd get 2 long weekends.
Beautiful.
I can't believe
I mean, I wanted to propose that because counsel is here from California.
He's got a very young daughter. My daughter is not seeing me either. It would be great.
It goes with the territory, right?
Of course.
But I do understand. And I was going to offer that so that they'd be off that Wednesday, Thursday, Friday. That's one day, and it would be a full day.
Wonderful. Awesome. Thank you.
One other issue, Your Honor.
another issue.
Okay.
The Commonwealth filed a motion to exclude Mr. Kearney while certain witnesses are testifying, and some of those witnesses are here today, as is Mr. Kearney.
All right. Does the defendant take any position on this?
No.
Okay. I just was told someone wanted to tell me that Tim Bradel was on his way, so I read the Commonwealth's motion. If Mr. Bradel is here, he has a right to be heard, as well as... I'm concerned on this motion, just so it's clear. You're moving to exclude Aidan Kearney, who has been given SJC 119 status recently. So we will have a hearing on your motion. Mr. Bradel has a right to be heard. Mr. Kearney has a right to be heard, but you're not asking for him to be excluded during the witness who is presently on the stand, right?
No.
Okay. I just took a quick look at the names. I need to highlight them. And your witness after Julie Albert is through?
I'll remind you guys that Aidan Kearney is the podcaster known as Turtle Boy, who was really instrumental in some of his behind the scenes research, if you will, or investigation of this trial. He was really calling out the Albert family and this investigation. And the Commonwealth was none too happy with him. And a lot of the witnesses in the trial were accusing him of harassment. He is currently facing witness tampering charges related to the Karen Reed trials. And so some of the witnesses that they were calling to the stand did not want to testify in front of him. So that's one of the things they're discussing.
Cole Albert.
Okay. Is she on this list?
She's not on the list as a named victim, Your Honor. But part of Mr. Kearney's activities have included her residence. So I think what they did as far as the main victim was they put Brian Albert, her husband. But I would submit, I think she falls into that category.
All right. So we will have a hearing, I guess, after this witness. All right.
That's fine. Thank you.
Are we all set?
Yes.
Okay. Thank you.
I want to tell y'all about this fan. Everybody's talking about this fan.
Okay. Feel free to stand up.
I didn't want to do this without the court's permission.
Another one?
I don't know that Mr. Lally has opened the door to this, but I neglected to ask this witness about the text messages that they exchanged. It may be just a couple of questions just to...
Who is they?
I'm sorry, this witness and Courtney Proctor, she had testified that rarely did they call. It was mainly with text messages. I just wanted to highlight, in addition to the 67 calls, there were numerous text messages. I wouldn't go deeply into it, but again, I realize he is not opening the door. I'd have to get the court's permission to do that on recross.
What's the Commonwealth's position?
It's outside the scope.
So is that an objection?
Yes.
I'm going to sustain the objection.
Thank you.
So while you're here, a couple of things. In an effort to move this case along with the next witness, not everybody needs to identify the inside of the waterfall. They can certainly identify where they sat or whatever you want, just the basics.
I'm done with the video from the waterfall until...
Okay, but the repetitive nature, like it was with the storm. So if we could try and avoid that.
Uh-huh.
And maybe it's just a personal pet peeve, but...
What am I doing?
The first question we've never met. Sometimes it's two questions. No, it's not just that I don't like it. You're not testifying. And I would have let it go, but Mr. Jackson picked up on it and started doing it a couple of times. If it becomes crucial to it, ask for permission by coming to sidebar.
Okay, that's fine.
And sometimes it might. I've had occasions one occasion where I had to do it and I never did it.
Gotcha.
But in an effort to sort of move things along, I think we have this issue now before your next witness.
Yes.
I was told Mr. Bradel was here, and then I received something saying Mr. Bradel had no idea about this motion.
Okay, so she's upset that when the attorney comes up to question the witness, they start off by saying, "Have we ever met before today?" So she doesn't want them to ask that question. This is weird. That's weird to me.
I don't know if he's even planning on being here.
Like,
I texted him when I saw him, and
how is that moving this along any faster than all of these sidebars? Oh my God.
I was actually in the process of texting him to notify him. I didn't know if he knew or not.
I saw him in the hall when I came in.
I think he knows now. Yeah.
So that's what I called Mr. Rose for, to order bagels and coffee for the jurors in case this takes a while. Let me send them out, and then we'll figure out what we are going to do.
Good morning, Lisa. You're actually, your testimony does not look complete.
Thank you.
Right, so let's let the jurors go first, because we're doing something that may take a little while, so we got you coffee and bagels. So it'll be a little bit longer break. Are you okay?
Mr. President, jury,
Just fold your notebooks up, please. Fold your notebooks and leave them on the chair, please. Anything coming out there?
All right. Can we call Mr. Bradel in?
Please, let's get to
Are we doing this at sidebar?
I'll have him come to sidebar to see how we all want to do this. Is he out there? Is Tim Bradel out there?
another sidebar.
Mr. Yannetti, you said you texted him about this?
I did, yes. Here he is.
Good morning, Your Honor.
Hi, Mr. Bradel. Why don't you come on over? I'm actually doing this. This is a microphone. So if you would come over.
Okay.
So I have Commonwealth's motion to exclude Mr. Kearney, who I don't know if you're going to represent him on this motion, but I know you represent him in a pending case in this courthouse. So the Commonwealth's motion to exclude him in connection with this case from the proceedings regarding certain witnesses.
Okay. So this is news to me, Your Honor,
Okay.
and I don't have service of it. I would.
Okay. So
I'm here on Mr. Curry, not on Mr. Kearney.
nothing can happen on Mr. Curry because
No, of course. I figured I was just going to get a date and be out of here. So this is all news to me.
Okay. Have you seen the motion? Because Mr. Yannetti said he texted you.
He texted me that there was a motion, but not.
Okay.
But I don't have the motion. I just looked on mass courts, and it's not in this court. So I don't know anything about this.
So we'll give you a copy of the motion.
Okay.
We'll give you some time to talk to Mr. Kearney. There is no case on this.
Aiden
Okay.
Kearney is sitting
It's sort
right
of
in the
an
back.
ancillary matter in the criminal case.
That's him right there in the white blazer with the black shirt. That is Aiden Kearney sitting in the courtroom. Who they're talking to at sidebar is his attorney. And so he's saying, I never saw a motion to exclude him from the courtroom during these testimonies. So that's what they're discussing.
Miss Reed.
Yes.
And it's a motion that I'd like to have a hearing on it in about 15, 20 minutes. Okay?
Okay.
So I'll give you that time to speak to Mr. Kearney. Take a look at the motion.
Okay.
I don't know that the defendants have any. They told me earlier they don't have a position on the motion.
Okay.
Logistically, I don't know how to set up. Do you want to be present or do you want us to separate you from counsel table?
That's a great point. That's a great point, Your Honor.
That's why I called Mr. Bradel while I had you all here.
For this purpose, I don't think that it involves Miss Reed's interests or taking a position on it legally or otherwise. So I would ask that she sort of be separated away from it. I don't even like the optic.
Well, that's why I asked.
Yeah, I think that's a great idea.
All right. So we will excuse the parties on the Reed matter. Okay?
Okay. Okay.
I may have a procedural objection, Your Honor, just so you know.
Okay. Yes, you can. This is a motion that's filed in a criminal case that I have to act on.
Sure. I appreciate it.
And just so you know, Mr. Lally said that our next witness, though not a named witness on this, also, Mr. Lally, has the witness herself expressed concern?
Yeah.
So a hearing is not worse than a sidebar. Unless you mean if it drags it out more. Yes, the hearings are also done outside of the presence of the jury. So the jury is not privy to any discussions that's happening in a hearing. And it has to do with the case, but is aside from the case, I guess, if that makes sense. So that's the reason why it's outside of the presence of the jury. It's usually some legality that they need to work out before they decide whether or not to bring it before the jury. So usually that's why they have these mini hearings within the trial. I hope I explained that well.
Yes.
Okay. And maybe you want to talk to the Commonwealth about this.
And, Your Honor, for the record, this whole thing is sealed, correct?
Yes. And I said that to Margaret. I should have said it to you as well. Yes. And the hearing will be sealed.
Thank you.
We'll do it in open court somehow, I guess. Or maybe not. But we'll deal with this. Okay? All right. So I'll see you in about 10-15 minutes, Mr. Bradle.
Very good.
And the Commonwealth.
Thank you.
And I know you have all of your paperwork on the table. You're free to leave it. Nobody will see it.
That's fine. What time would you like us back?
So the jury just went out 10 minutes ago. Let's say 10:45.
Okay, that's fine.
Thank you.
Thank you.
Okay.
Break for
Thank you. Please be seated. Close that. Back on the record on the Reed matter.
All right, sort of a side issue in the Reed matter. So the defendant and her lawyers have been excused. Okay, so why don't counsel identify yourselves, please?
So, Adam Lally for the Commonwealth, Your Honor.
Laura McLaughlin for the Commonwealth.
All right, good morning.
Good morning, Your Honor. Timothy Bradle on behalf of non-party Aidan Carney, who for the record is present in the courtroom.
Does Mr. Carney want to sit with you?
I think he's okay right there.
Okay.
If that's all right, Your Honor.
All right. So, Commonwealth, so I do want to say a question before we begin. Commonwealth, in your motion to exclude an individual charged with witness intimidation and connect.
Okay, really quickly, I put the question in the chat, but do you all want to skip ahead and skip the hearing? I believe it gives context surrounding the entire trial and the foolishness that was happening, but I'm happy to skip ahead if you guys are not interested, so let me know.
Connection with this case from the courtroom during the testimony of certain witnesses. Before we begin, are you advancing the concerns of the DA's office or the concerns of the witnesses themselves, or both?
Both, Your Honor.
Okay,
Judge,
so
if I may, I'm sorry to jump in, but just if I may, I do have what I think is a pretty substantial procedural objection.
Okay.
Maybe I'd ask that you sort of just make a quick bifurcation of the issues here, and we can address the procedural issue before we get into the substance of the motion.
Sure, I'll hear you.
We could. Thank you very much, Your Honor. Your Honor, just so the record is clear, because we may need an appellate record in this case.
Okay.
But I was here in the Norfolk Superior Court today, completely unrelated to Mr. Carney, my client, as you know, in the other matters. And I was here today on the matter of Commonwealth versus Tylee Curry for a motion to suppress.
Which is a case that I am in the middle of that motion to suppress with you.
Exactly. And I actually figured that we wouldn't do the motion and get a date, but I was fully focused on that matter and had no notice whatsoever that the Commonwealth was in the Reed matter, was seeking to exclude my client as a journalist from this courtroom. The first thing is that, and I know the court has a job to do in terms of ruling on this motion, and that's fine. And I ask that the ruling be that it be denied on procedural grounds. The procedural grounds are, Judge, that there's been no service of process whatsoever on a case where the government is seeking to essentially trample all over my client's First Amendment rights as a journalist.
Exactly.
On 15 minutes notice. You know, I know you gave me the thing 15 or 20 minutes ago.
And it's more than a half an hour, but I understand.
All right, well, you get the point. So, you know, this is not something that I can process and absorb and make any sort of cogent arguments on the merits of the motion on that time period. And I'm sure that the court respects that. I'm trying to address it as best I can, but I think that the procedural issues here should control. And here's the procedural situation, Your Honor, that the government filed this 6-page motion. There's a footnote 2 that refers to them serving this motion on May 8th to the Associated Press. Why they couldn't just pull up my email and serve me is an open question that I'd like an answer to in open court. So they can serve the AP 2 days ago, but they can wait and not even serve me with the motion when I get here to court today on a completely unrelated matter, I might add. So there's some funny business going on here, and there's been nothing but funny business from where I sit from the Commonwealth on Mr. Carney's matters. And here we go again. So I don't appreciate that from counsel, from the Norfolk County DA's office, number one.
Yikes.
Number two, Your Honor.
There's more? Uh-oh. Yeah, go back to your note.
Mr. Carney has covered this case and written about 350 news articles on this case. He has developed evidentiary scoops on this case that have added to the quantum of evidence in the matter. Mm-hmm. He's never caused a problem. He wishes to be in the galley of journalists like everyone else and cover the case. There's never been a problem whatsoever. This is more personalized retaliation from the Norfolk County DA's office against Mr. Carney. Another point, Your Honor, is that this matter, as far as the Commonwealth is concerned, is res judicata times 2. Judge Krupp in this very court addressed this exact issue about Mr. Carney covering this matter, being in the courtroom with witnesses that had a stay-away order. All the same people that the government is trying to have another bite at the apple with here. All these people, this was adjudicated fully with the special assistant DA before Judge Krupp, and Judge Krupp ruled against the Commonwealth. Judge Krupp said that Mr. Carney was able to be in the courthouse covering this case regardless of any of these witnesses in the stay-away order. The stay-away order was exempted from Mr. Carney's presence in the courtroom, rather, was accepted from the stay-away order.
Okay.
So this is done. This has been adjudicated. It's been adjudicated again, Your Honor, by Judge Pomeroy across the street in the district court. One of these people associated with Mr. Carney's detractors, Ms. Gattani, has taken up with the Commonwealth and sought charges and sought a restraining order against my client. And Judge Pomeroy recently, as recently, I think it was a couple of weeks ago, we were across the street, Your Honor, seeking to vacate the order under the doctrine of unclean hands because this plaintiff keeps trying to contact my client while under a restraining order. Putting that aside, the ruling in that matter, Judge, was another ruling in support of.
Okay, I'm pausing because I don't know if you guys are following what's happening, but I just want to make sure that everybody is following. What he is saying is that there's already been a ruling that all of the witnesses that have asked for a stay-away order against Aiden Carney, it has already been ruled in another courtroom that the covering of the trial is separate from that issue and that he should still be able to cover this trial and be in the courtroom aside from the stay away orders. So he's saying, I don't even know why we're here because this has already been decided on. And also, one of the witnesses that has a stay away order has also been contacting the very person that they want to stay away. What is happening?
Mr. Carney's First Amendment rights. It was another ruling that said Mr. Carney was not subject to the restraining order in any court of the Commonwealth. And the reason we brought that motion, Your Honor, was because these same witnesses that the government here is again trying to advocate for their own personal issues, those same witnesses somehow took up with this plaintiff across the street, Ms. Gattani, brought her to court here in prior Reed proceedings to kick out Mr. Carney, because at the time she had an operative order against him. And Mr. Carney, to his credit, got up and left and got out of here. And that situation was what we addressed across the street with Judge Pomeroy. He agreed with us and said, you can go to court, you can cover this case. So number two, litigation number two, this has been established. Mr. Carney followed all proper channels. We worked with the SJC media office. He has a press pass. He's doing everything in accordance with all of the rules and regulations that are in place. He's been harassed, and we have it on video, by other so-called journalists on this case at the steps of the courthouse. And he just wants to be here. He doesn't want to be an issue in this case. He wants to sit here and cover the case. He's done his job. He wants to watch the trial unfold. And he has an absolute fundamental First Amendment right to do so within the confines of this courtroom and within the confines of time, place, and manner restrictions. He's followed everything, and he's here. We've gone through all of these hurdles, Your Honor, and Mr. Carney triumphed, as he should, because it's the First Amendment that needs to triumph here, not any particular person. And that's what he's doing. And there's absolutely no reason for the government to sneak behind my back to interfere with his First Amendment rights. It's outrageous, and on procedural grounds, I ask you to deny the motion for all of those reasons. And if the court has some hesitancy to do so with respect to these procedural issues, I ask that you set a date give me 7 days or so that I can properly respond to this motion on the merits of whatever's in these 6 pages of the motion that I haven't been able to look at. So thank you for hearing me, Your Honor.
All right, sure. And you wanted a response to your question from Mr. Lally on why you were not served, but the Associated Press was served.
That's correct.
So if you talk about that in the procedural part of this, Mr. Lally?
Yes, Your Honor. Simply put, Mr. Bradel, neither Mr. Bradel nor Mr. Kearney are parties to the case. I can't presume that Mr. Bradel's representation on one criminal case is going to extend to a motion of which he would be at best a third party on a separate criminal case. We are required under the SJC rules to serve it upon the Associated Press, which we did.
Okay. So I think that's your record now, Mr. Bradel?
Thank you.
Okay, on the procedural issue, okay? We have a jury out. I do want to address the merits of this as best we can. And Mr. Bradel, at the end of this hearing, whatever I end up doing, if you want to come back and readdress it when there's more time, depending on how I rule, I'll give you the opportunity to do so. But I have to get this trial moving at this point one way or the other. So I'm going to hear the Commonwealth on their motion. Then I'll hear you, Mr. Bradel, to the extent that you can respond, okay? All right. Mr. Lally, I'll hear you on your motion.
Your Honor, very shortly, very simply put, this is an instance in which the Commonwealth is not asking that Mr. Kearney not be allowed to cover the case or that he not be allowed to watch the trial. What we're requesting is a partial closure of one individual. And the legal standard for that is essentially a substantial reason. Substantial reason, Your Honor, being that Mr. Kearney has been indicted and has open cases for intimidating witnesses, specifically witnesses in this case. He has confirmed statements indicating publicly that his actions that he's taken in regard to those indictments were to prevent the case from ever going to trial and to intimidate those witnesses. Those witnesses will be called to testify in this case, and what the Commonwealth is simply requesting is that he be excluded physically from the courtroom, not excluded from watching the trial, not excluded from covering the trial, but excluded physically from the courtroom while those witnesses are testifying from the stand.
And the witnesses you told me have expressed concern. What do you say about that?
Yes, Your Honor. The witnesses have expressed concern. The Commonwealth is concerned as to his presence affecting their testimony or their ability to recall. And for all of those reasons, the Commonwealth would submit the administration of justice and the witnesses being able to testify, as well as the witnesses' own concerns are more than meet the test of the substantial reason for Mr. Kearney's exclusion during the course of their testimony.
Okay. Mr. Bradel?
Your Honor, the witness's concern has no legal materiality under the law. So the answer that I have is, so what? The witness's concern, where does that fit into the law here, Your Honor? This matter's been adjudicated twice. Mr. Carney has the right to speak on the case. He's gone through all the proper channels to be here. He is not in any way wants to or is trying to make any issue of his presence here. And he's just trying to cover the case as best he can. And this is just a personal vendetta that's been carried out by the Norfolk County DA's office against Mr. Carney. And, you know, this is where the court needs to hold the line on the First Amendment. You know, this witness intimidation statute, Your Honor, is an absolute abomination. It is going to be struck down. It's just a matter of time. And this is just a continuation of everything the special counsel's been doing to Mr. Carney, and now the office itself is doing it. There's no reason for this motion to be allowed, Your Honor. There's no discomfort exception to the First Amendment, Your Honor. There's been absolutely nothing advanced, especially on an emergency basis, which is, I assume, why this is being done with no notice. There's been no establishment of any emergency. There's been no conduct whatsoever on the part of Mr. Carney to justify this motion. And I did happen to see some reference to the Chesney trial about published, it's something to the effect of doxing a seated juror. That is false. Mr. Carney wrote a story on a juror after the jury was discharged. There's absolutely no prohibition or problem or issue with that. And it is absolutely protected conduct by the First Amendment. And it is not in any way a grounds for this court or the Commonwealth to assert any wrongdoing against him.
So I can assure you I am not considering that incident in this. You all know I was the judge. I am not considering that experience in this motion.
Thank you.
Anything further, Mr. Bradle?
Thank you.
All right. So, Mr. Bradle, I agree with you that Mr. Kearney is certified by the Office of Public Information pursuant to SJC Rule 119, and that he has a right to be here today. He arrived timely, and that he is registered. I have honored that 119 registration today, and I will continue to honor that. However, my role in this case, Commonwealth versus Karen Reed, is to assure that the defendant's constitutional right to a fair trial are honored and upheld. And because of the chilling effect that Mr. Kearney's presence, I find, will have on the witness's testimony, I'm going to excuse him while the named witnesses in the Commonwealth's motion, Julie Nagel, Christopher Albert, Colin Albert, Michael Proctor, Jennifer McCabe, Matthew McCabe, Brian Albert, and Yuri Buchanan. And the Commonwealth also today requested Nicole Albert because of the incidents that are reportedly.
I know you are lying. The Michael Proctor and Yuri Buchanan are intimidated by a member of the press. They are cops. You have got to be kidding me. You have got to be kidding me. Oh my God.
They have been held at her home. I'm going to excuse him during all of that testimony. Now, in my media order, if you have it, I'm sure your client has it because they're handed out to the press. Under number 1, I say that anyone leaving the courtroom to the media during the trial proceedings may lose their seat and may not be permitted re-entry unless there is available seating. That will not happen to Mr. Kearney. I will not take away his seat today. For other witnesses who are not subject to this order, that seat will remain empty. No other person of the media will be able to take that seat in his absence. Okay?
Your Honor, one last thing, if I may, just came to me as I was standing here. Extension in same regard as to Nicole Albert for the address would be Brian Albert Jr., son of Brian and Nicole Albert, lives at the same address.
It's for the same reason, so Brian Albert Jr. All right, so those are my findings, Mr. Bradle. It should give you enough to seek appellate action if you wish. Okay? All right, thank you for being here.
To them. We should still.
All right, so I'll take a short recess. We can bring counsel back in and Ms. Reed back in, and
Wow.
we'll proceed with the
They don't want
trial.
him in there so they can continue to stay alive. Yeah. All these people should be respected.
All right, jurors, once again, thank you very much for your patience. Your next witness, Mr. Lally?
Yes, Your Honor. The Commonwealth call Ms. Nicole Albert to the stand. From that next morning, how is it that you wake up the next morning?
Well, at some point between 6 and 6:30 that morning, my sister Jennifer came bursting into my bedroom.
And comes bursting into your bedroom, is that correct?
Yes.
And what, if any, how would you describe your sister Jennifer, and how was she sort of acting at that time?
Well, she came in, my husband and I just kind of sat up in bed, and she's saying, he's out in the snow, we found him out in the snow, we don't know if he's okay. And my immediate thought was just that something had happened to one of my children, something had happened to one of her children. I couldn't imagine why she was in my bedroom at this time in the morning. And I'm like, Jennifer, what are you talking about? And she's like,
Objection.
All right, next question.
Your Honor, if I may? Can we approach?
Okay.
Another sidebar.
What is the objection, Miss Little?
It's hearsay, Your Honor.
Okay.
It is hearsay, but I believe it falls under an exception based on the state of minds as well as its. I'm not offering it for the truth of the matter asserted. I'm offering it, basically, that's what gets this witness downstairs in the house and onto the sort of next observations as far as where she goes, what she sees, effect on the listeners, essentially.
What do you expect to ask her? And what do you expect her to say?
So I just expect her to say that eventually her sister, as to John O'Keefe, and she still at that point doesn't know what she's talking about. And this sister, Jennifer, says, the police are downstairs and they want to talk to you. And that's what causes her and her husband to get up and go downstairs.
I think he can just ask the witness what happened next.
That's fine. Ask the witness what happened next. If she answers this way, I'll allow it in. Okay.
Whatever they want.
Let me back you up just for a second and I'll go back. As far as when your sister Jennifer comes into your bedroom, do you know about what time that was?
Between 6 and 6:30.
And it's fair to say that's not a normal occurrence?
No, it's never happened before.
And if you could just describe your sister Jennifer's demeanor when she first comes into your bedroom.
She was hysterical.
And she says some things to you, and then where did you go from there?
Well, I tried to ask her what was going on, what is she talking about, and she told us.
Objection, Your Honor.
No, I'm going to allow that.
So she told us, what had happened or what she had just witnessed outside, and we were just trying to understand what she's saying. Like I said, I didn't know if it was something that happened to one of her kids, one of my kids. And so I said, Jennifer, I don't know what you're talking about. So she finally was like, well, John, remember John from last night at the waterfall? And I'm like, what do you mean? How could you be outside? And she's like, you got to get up. The police are here and they want to talk to you. So my husband and I got up. I think I threw on a sweatshirt. And we started to walk down the stairs. As we walked down the stairs into that foyer area.
John from the waterfall, as if they don't know the man? What? This sounds, oh my goodness.
Officer Link was walking in the house.
As far as how the conversation ended, at any point during the conversation, did yourself or your sister or your husband or Did anyone ever sort of end the conversation or tell the officers to leave the home or anything like that?
No, no.
And you welcomed them inside once you realized what was going on?
Yes, absolutely. And I believe another officer had come in as well.
Now,
Girl.
after the officers leave from your home, what happened then?
So I believe they left and said that someone would be in touch with us, the state police or somebody. So they left and we were all just kind of sitting there in shock. You know, I'm asking Jennifer, like, you know, what happened? How did you end up here? Like, what's going on?
Objection, Your Honor.
Sustained. Next question, please.
Your Honor, as far as... Maybe we close just briefly.
Okay.
Same objection, Miss Little.
He needs guidance.
Yes, Your Honor.
Say next.
Okay. Mr. Lally?
I understand, but what this witness said to someone else is not hearsay.
Yes, it is.
So what is the conversation you intend to?
Just as far as she was asking what happened. But again, I can make clear to the witness that she is not to respond as to anything that was said back to her. But her asking questions, I think, is perfectly reasonable.
You're asking questions. It's an out-of-court statement offered for the truth of the matter asserted. She can't testify to things she said. She also can't testify to things that she heard other people say.
You can ask her what she did, and as a result of any conversation, what she did. You can't ask her the specifics.
Go ahead, Miss Little. Miss Little says she cannot testify to that.
And so, Ms. Albert, without any sort of specifics of your conversation with Ms. McCabe, you had a conversation with her, is that correct?
Yes.
And about how long did that conversation go on for in your case?
With just her? I mean, we were all just kind of sitting around the table talking.
And just to be clear, when we say all, who is all at this point?
It was me, my husband, and Jennifer and Matt.
And at some point later on, did other people come over here?
Yes, at some point, my friend Brian Higgins, my husband's friend Brian Higgins came over.
No, you said your friend.
And you know how he came to be at your house that morning?
I believe Brian called him to let him know. I mean, he had been with us the night before, and I think he had been friends with John and Karen's.
Oh, that's good. I didn't know that. So after the police came to the house, they called Brian Higgins back to the house. And Brian Higgins is who most people suspect is the real culprit. They really believe he's the one that did this to John. So this is interesting.
So Brian thought he should let him know.
I have nothing further for this witness, John.
All right, Ms. Little.
Get Eliza.
I know this is kind of hard to see because the number's blocking it.
Yeah.
But does that appear to be your husband to the left, kind of in a fighting stance?
Yeah, I think so.
Okay. Ms. Albert, when your husband drinks, does he often...
So I'm sorry, are we taking this down or keeping it up?
Yes, Your Honor, you can take it down.
Okay, thank you.
Ms. Albert, when your husband drinks, does he often get into sort of these practice sparring, practice fighting stances? Is that common for him?
Objection.
No, I'm going to allow it.
No, I don't think so.
So this type of behavior was unusual for him?
No, I think they were just fooling around. I don't think there was anything much to it.
My question was, is it unusual for you to see him sort of practice fighting?
I wouldn't call that practice fighting. I think they were just fooling around. And yeah, maybe I've seen him do that other times, but it was fooling around. They weren't practicing.
Let me put this a different way. You do know that your husband is a highly trained fighter, correct?
Objection.
I'll allow that.
Absolutely not.
Your husband has no fighting experience whatsoever?
A highly trained fighter? No, he's not.
He has boxing experience, correct?
Objection.
So I'm going to see you at sidebar on this, please.
Oh, they don't want that to get in. They don't
Mr.
have it.
Lally, what is the nature of your objection? And then I'll hear from you.
Relevance.
Your Honor, this is highly relevant. This goes first of all to the witness's credibility. It allows the jury to evaluate the circumstances that occurred that night right before they went to 34 Fairview. The witness has just stated that her husband has no fighting experience whatsoever.
Well, no. I think she said that he was not a highly trained fighter. I disagree with the Commonwealth. This is relevant, just the wrong witness. Brian Albert is the next witness.
I just have 2 more questions.
What are the other 2 questions?
I want to ask her if she knows whether her husband has a lot of training in boxing and whether he is highly skilled in fighting from being in the military.
I think you're going to get some pushback on the highly skilled. I think that's what the problem is.
I'll ask if he has just any general training and experience.
But he's the next witness.
So,
can you explain why you need it from her? You started out by saying it went to her credibility.
Well, she's just testified under oath that he has no experience, and she was reluctant to agree to the boxing as well.
She was.
That's not what she testified to.
I think what she hesitated to was the highly skilled. She gave you the boxing. Why don't you ask those 2 questions?
Thank you, Your Honor.
Lord, this thing is like
Ms. Albert, your husband has boxing experience, correct?
Yes.
He also has fighting experience from his training in the military, correct?
I don't know what fighting experience from the military means. I mean, he was in the Marine Corps. He was out of the Marine Corps in 1992.
But he had training through the Marine Corps and through the Boston Police Department with fighting and defensive tactics, correct?
I assume so.
trying to make that thing small.
Ms. Albert, you don't have Chloe anymore, do you?
Nope.
In May of 2022, 4 months after Mr. O'Keefe's death, you got rid of your family dog of 6 years.
Objection.
Is that true? Is that when you got rid of your dog?
I did not get rid of my dog. I rehomed my dog.
Same way. Tomato.
Your dog is no longer in the Canton area, correct?
No, but I know where she is. She's in Vermont. And that previous testimony, that information has all been given. So if she was ever needed for anything, we know where she is.
Is that testimony given to the defense?
Probably.
Was I present at the hearing where you testified about this?
Objection, Your Honor.
Sustained.
Look at her face.
Your Honor, can we approach?
Sure.
Let's approach. This is number 6, guys. Cause she lying.
I want to ask her a question about, the nature of testimony. Obviously, that was in front of the federal grand jury. I don't want to overstep. I believe she's trying to reference that. But I don't want the jury to be left with this false...
You're talking pretty loudly.
Sorry. I don't want the jury to be left with a false impression that information was provided to us.
So did you...
It was provided to you.
Where is this testimony?
It's in the federal grand jury minutes.
But not by the Commonwealth.
Oh, I'm not going to split hairs on that.
What difference does that make?
So I'm not going to allow you to get into that. So she said she testified about it, and you were aware of that.
Okay, thank you. May I have one moment?
Sure.
Thank you. Okay.
Ms. Albert, you're aware that we actually sought records regarding Chloe and her bike history, correct?
Objection, Your Honor.
Was it from this witness?
It was.
That's a yes or no from there. Yes or no?
Well, it was from a custodian.
Okay. I'm going to sustain the objection.
All right, Ms. Albert, I want to direct your attention back to the early morning of January 29th.
I want to talk about Chloe and her.
You testified that everyone who arrived at your house just after midnight was sort of generally gathered at the table in the kitchen area, correct?
Yes.
And over the course of that evening, you had never heard any sort of disruption inside, correct?
No.
You didn't hear a crash?
There needs to be an answer.
Sorry, no.
You certainly never heard any screaming or yelling?
No.
And you never heard the screech of any brakes outside, correct?
Correct.
Okay. On July 20th, 2023, you testified before a grand jury, and Mr. Lally was not there, correct? And Adrian McLaughlin was also not there, correct?
Okay.
Do you recall that?
Yes.
And you were specifically asked during the course of that hearing where everyone was positioned around the table that night.
Mm-hmm.
You remember that sort of line of questioning?
Yeah.
And you explained that your sister Jennifer was seated next to Brian Jr.
Objection. Is there a question?
We're getting that question, so go ahead.
You were very specific about kind of how people were seated at that table that night. Do you remember that testimony? You explained that Jennifer was seated next to Brian Jr. and that the kid was across from him. Do you recall that?
Yep.
But when you were asked where your husband and Brian Higgins were positioned at the table, you weren't able to place them there. Isn't that true?
Because I don't believe they ever sat at that table.
And what you told the grand jury during that hearing was that at least at one point, they had left the room and they were outside of your view, correct?
I'm not sure I said that.
Told the jury that you were cleaning and you weren't sure where they went, correct?
Well, initially when I first came in the house and I was doing my thing, I don't remember exactly where
And
they were.
you told the grand jury that you don't recall seeing them at the table, but you don't recall where they went because you were kind of focused on cleaning, correct?
Right.
And there was one point at which you said that you joined them in family.
Yes.
Is that right? But while you were cleaning, you said, I don't really know what they were doing, but they weren't there, correct?
Yes.
So you recall your husband and Brian Higgins left your view and went to some other place in the house that evening, correct?
They could have.
Ms. Albert, how many steps is it from the front door to the basement?
Steps?
It's a poorly worded question. I will rephrase it. When you open the front door of your house, how many steps does it take to get to the door to the basement?
4 or 5.
You testified earlier that Brian Higgins left 34 Fairview first, correct?
Yes.
Then Matt McCabe, Jennifer McCabe, Sarah Levinson, and Julie Nagel left together, correct?
Yes.
And the very last person to leave your house that night, you said today, in your room, was your daughter, Caitlin. Correct?
Yes.
And you said she left your house close to 2 a.m. Is that right?
Yep.
Ms. Albert, that's not what you told Sergeant Lank on January 29th, 2022, is it?
I don't recall what I told him.
Would it refresh your recollection to take a look at your statement to Sergeant Lank?
Sure.
May I approach the witness, Your Honor?
Yes.
Woo. Okay, I'd like to direct your attention to page 2 of this.
Would you show the prosecutor, please?
Yes. Just go ahead and use your question.
Your Honor, may we approach just briefly?
Okay.
If you're counting, we're up to number 7.
Obviously, Attorney Little can show whatever she likes to the witness to refresh her memory, if that's what we are doing here. But when she refers to it as her statement and then shows a police officer's report, I just don't want that misconstrued as far as what she is showing to the witness.
I apologize. I won't do that again.
Okay.
Ms. Little, maybe you can clarify that.
Sure. May I approach?
Yes.
Okay. I'd like you to look at page 2. And you don't need need to read it out loud, but if you could read this very last paragraph here.
Down here, 7? Oh,
Actually, this section right
Okay.
here, the second paragraph to the bottom.
Mhm.
You don't need to read it out loud, just look up once you're done.
And are you going to clarify that, Ms. Little? Statement?
Oh, how can I approach, Your Honor?
D-
What? Can she approach or
Ms.
not?
Albert, this is just a police report containing an interview that's conducted, correct?
Yes.
With Sergeant Lang on January 29th, is that right?
yes, the morning of.
Thank you.
So is that not her statement? What are we doing? What are we doing?
Ms. Albert, what's the first thing you remember waking up to on the morning of January 29th?
My sister bombing into my bedroom.
Okay. Your Honor, if we could approach.
Okay, approach sidebar, or you? Okay.
Yes.
8. What is going on? She must have said something different in another statement.
I'd like to be able to show the witness, this demonstrative. It's 34 Fairview, the crime scene photos. As you've seen, they are not the best.
Keep your voice down.
It's to scale. I think it will assist the jury of being able to determine where certain things are on the property.
Mr. Lally, the objection?
As I told Miss Little, as long as the witness can recognize it and adopt it as representative of her home, then I have no objection.
All right. So you just want to use it as a chalk instead of an exhibit?
Yes, Your Honor.
Okay.
And do I have permission to publish this to the jury?
Okay.
Okay, thank you.
So, Ms. Little, we're going to mark what you have in your hand for identification.
We have 10 more minutes, guys.
Thank you.
Robert, I'd like to show you a photograph which purports to be.
Just show her the photograph.
Ms. Albert, do you recognize that photograph?
Yep.
What is it?
It's a picture of my house.
Does it appear to be generally to scale?
What?
Do you recognize sort of the flagpole in the yard,
Yes.
the house,
Yep.
the driveway?
Mm-hmm.
And that looks
Yes.
accurate. And that looks accurate in terms of scale, correct?
Yes.
Permission to publish?
Sure.
Ms. Albert, where is your bedroom located?
Want me to show it?
Yes, if you could explain.
Right up here.
So, your bedroom is in the upper left-hand quadrant, correct?
Mm-hmm. Yes.
The far left window, that's your bedroom window.
Yep.
That
Right.
flagpole is
The
where
two
they
of them.
found John. They're trying to.
Ms. Albert,
How could you not
what
have
about
heard
the
anything?
2 calls that you received from your sister at 6:07 and 6:08 a.m., which were answered?
I never answered any phone calls from my sister that morning.
You're aware that the Celebrite records indicated that you answered 2 calls from your sister.
Objection, Your Honor.
On 6:08 a.m.
The objection sustained.
Your Honor, may I approach the witness?
Okay.
The phone records show she answered.
Ms. Albert,
Happening.
you received.
If I could just see what's being shown to the witness before. Thank you. May we approach?
Okay.
Oh gosh.
I'm going to take
I heard us those records.
What is the objection?
I don't know how this witness is supposed to authenticate a Celebrite report of someone else's home.
What is your question?
My question is just, does this refresh your recollection as to the 2 calls you received at 6:07 and 6:08, which were answered?
But you incorporated in your question that she answered them, right? And she said no.
Mr. Lally used a Celebrite report with another witness yesterday.
he definitely.
The Celebrite. Are these reports in evidence?
I don't have any objection to them coming into evidence, but no, they are not in evidence.
So ask her if she recognizes it, and ask her if it refreshes her recollection as to only calls not answered, anything like that, and see if it does. And we'll likely take a break after that.
Okay.
But let's mark it for identification.
All right.
The judge was going to try to keep out this record when she allowed him. If you guys remember last week, they had an objection to this witness using the Celebrite records to say whether or not these were her phone records to authenticate them, and the judge overruled that for the defense. But now, that the defense wants to use a Celebrite record, she was going to exclude this.
All right, so let's mark one for identification, please, Ms. Little.
Thank you.
Okay, and you can give it back to Ms. Albert.
Thank you.
And you can go back and ask a question, and let's see where we go with this, okay?
Ms. Albert, do you recognize this document?
Recognize it?
Do you know what it is?
Well, yeah, I see what it is.
Does it refresh your recollection as to the 2 calls you received on the morning of January 29th?
It says here 2 calls were placed.
Okay, don't read it, but you were asked a specific question. So if you could answer the question, please.
Does that refresh your recollection to the 2 calls you received from your sister on the morning of January 29th?
She may have placed those phone calls to me, but I never answered them.
You received a call from Jennifer McCabe on January 29th at 6:07:42 a.m. that lasted for 9 seconds, correct?
She may have placed a phone call to me. I never answered it. I never spoke to her that morning.
You also received a second call from your sister at 6:08:17 a.m. that lasted for 7 seconds, correct?
Objection.
Go ahead and answer that.
It says that, but I never answered a phone call from my sister Jennifer that morning.
You're aware that cell phone companies have what are called tolling records, correct? That show if there's a voicemail or something of that nature.
Objection, Your Honor.
Sustained.
Ms. Albert, it's your testimony here today that you never spoke to your sister that morning.
I never spoke to my sister on the phone that morning.
Who else was in your bedroom that morning?
Me and my husband.
You and Brian Albert were the only 2 individuals who could have answered those calls that morning, correct?
We were the only 2 people in the room, besides the dog.
And at 6:07 a.m., someone had a 9-second call with Jennifer McCabe, correct?
Objection.
All right, sustained. And you've got more for this witness, I imagine, Ms. Little?
Yes, Your Honor.
Okay, so we'll take the luncheon recess, folks. It's 1 o'clock.
Your Honor, before we start, Exhibit S, which was marked for identification, I believe the proper foundation is laid. I'd ask.
So let's not do that from there. Let me see it, please.
Sure.
Do we have S as in Sam, or X?
Identification.
S as in Sam?
Yes.
Thank you. Yes. Oh, it wasn't today?
Why don't you come to sidebar, folks?
Maybe it was X.
That's not it.
I thought you said S, as in Sam.
I thought it was S as in Sam.
I think we misheard when the clerk marked it.
It might have been X.
It might have been X. My apologies.
All right, so what do you say?
I believe we've laid the proper foundation for Exhibit X. We'd ask that it be in evidence.
Any objection?
No, I mean, it is not a photograph, and I just don't want the jury to be left with that misimpression. It's my understanding it's not a photograph. It's some kind of graphic rendering.
We will stipulate to that.
We'll stipulate it's not a photograph.
Okay. I don't want to read the stipulation on this into evidence. So if you are going to stipulate to it, either you say it or you say it.
Okay.
I think it would be best for you and Miss Little say that it's a stipulation.
Okay.
I would agree.
Okay. And before you put it in evidence.
Yes.
Okay.
The parties have stipulated that Exhibit X is a graphic representation of 34 Fairview.
Yeah, not a photo.
Not a photograph.
Okay, sure. Now you can approach the witness if you. Oh, you just want to put it into evidence now? Okay. So that will be our next exhibit. Madam Court Reporter? Thank you.
You actually need it.
Ms. Albert, you never received any voicemails from Jennifer McCabe on January 29th video.
Not that I'm aware of.
You also have never produced, pursuant to our request, any documentation about the whereabouts of Chloe.
The objection sustained. I'm going to strike that question. Disregard the question. Well, questions aren't evidence, so we can leave it on the record, but the objection sustained.
You've never turned over any information about the location of Chloe since the pendency of this case, have you?
Objection, Your Honor, may we approach?
I'm just going to sustain the objection.
Have you ever provided information about the whereabouts of Chloe to the Commonwealth?
Yes, I believe I have.
You have.
I believe so.
When did you do that?
Your Honor, may we approach?
Yes.
Baby, they do not want to talk about what
Your Honor, so over the luncheon break, attorney Gregory Henning was here with both Mrs. Albert and Mr. Albert, who are his clients. My understanding, and it's the first time I'm learning this, is that apparently there was some meeting that he had with the U.S. Attorney's Office in which they provided documentation related to them to the U.S. Attorney's Office. So I think when the witness is answering this question, she is answering in regard to that. Nothing has ever been turned over to my office or myself. So before we go down that road and into that, I think that's what a truthful answer would be to this. And obviously, based on the Commonwealth's motion in limine to exclude any reference to that, I just want to cut it off before we get there. I also don't think it's relevant in any way, shape, or form.
This is obviously the first time we are hearing about this. We've had motions in court regarding this information for a long time.
You've had. Do the two of you want to talk for just 1 minute? I'm not inclined to allow this questioning based on the representation of Mr. Lally.
I just don't want to leave the jury with the false impression that...
You've asked the same question 4 times after I sustained it twice. I understand. I'll let you, Mr. Jackson, talk with Miss Little for 2 seconds.
Can we suggest a stipulation that she's never provided that information to the Commonwealth or the defendant?
But I don't know that she has that obligation, and that's a whole different line of questioning. Do you want to stipulate to that?
No further questions.
For that reason, I think it leaves the impression that she somehow was hiding something, or she was never ordered to provide, or never even asked to provide anything. The issue I would have with the stipulation is it's...
All right. I'm going to end this inquiry right now, I guess. Okay.
Thank you, Your Honor.
No further questions.
Okay, thank you very much. All right, Ms. Albert, you are all set.
Thank you.
Is your next witness, Mr. Lally?
She was walking out.
Yes, Your Honor, the Commonwealth call, excuse me, Mr. Brian Albert to the stand. I have nothing further for this witness, Your Honor.
All right. Can I see counsel in sidebar for just a second, please?
So it's about 10 minutes of 4.
So during Brian Albert, her husband, during his examination, there were no sidebars. I wish we could have seen his examination though. I might have to go back and look up his examination just so we can watch it together at a later time.
It's been a long day. Do you want to start or do you want to wait until Monday?
I'd rather wait till Monday.
Mr. Yannetti, you asked Mr. McDermott about whether we do have that.
Yes. Your Honor, just to be clear, we are very happy with what the court announced. but I checked my notes and I just wanted to make sure that we were on the same page. And the court understood where we had been, if you don't mind me touching on.
Yes. So the 28th, I'm going to go back and ask them
if they can do a full.
Okay, so this is just a scheduling sidebar. So I'm just going to go ahead and end it with that. Let me just tell you guys before we wrap this up, the dog issue, because there were injuries to John O'Keefe that the defense viewed as possible bite marks, and we also are going to have expert witness testimony that they are some type of animal bite. This whole thing that they got rid of, rehomed, however they would like to word their dog Chloe that they had for 6 years. Chloe had a history of biting, attacking, etc. She was known to be an aggressive dog. She was a German Shepherd and I believe a former police dog. And so I believe that they're trying to just make sure nobody don't talk about Chloe. So to me, it's something that was being hidden in this trial, and they weaved that thing to try to make it be nothing, but it really was a big part of the trial. Yeah, she was running out of there. Anyway, so thank you guys for joining me for another Saturday of the Karen Reed trial sidebars. We have so many more days to go because this is only day 9 in the trial. A trial that lasted, I think, almost 2 months. So we got a ways to go. So thank you guys for spending another Saturday with me going over this trial. Please don't forget to like the live, to share the live. Get your friends to join the conversation maybe next Saturday. You guys have an amazing day today. Enjoy the rest of your weekend. And I'll see you guys back here next Saturday where we will continue our in-depth coverage of the Karen Reed trial.